Good morning, everyone. This is Ariella Wagner, the founder of SunRay Construction Solutions, and the wonderful Mark Cobb, a construction attorney that specializes in construction law. And today we are going to learn from Mark the top 4 mistakes that invalidate a Georgia lien. So without further ado, I will introduce Mark Cobb.
Thank you, Ariella. I appreciate that very much. As she mentioned, I am a Georgia construction attorney. We have 2 offices, an office in Atlanta and an office in South Georgia, and we cover the entire state of Georgia. My particular focus of practice is representing suppliers and subcontractors. So consequently, we have a lot of experience filing liens, and we understand the problems that can arise when a lien is filed if it's not filed properly. So today, we're going to cover very briefly the top 4 mistakes that can invalidate a Georgia lien. The very first lien that I've identified is the failure to understand Georgia's statutory construction notice requirements. Basically, in Georgia, certain claimants or potential claimants have to send a notice to owner or notice to contractor at the beginning of a project. So 2 quick definitions that we want to cover is a notice of commencement and then what is a notice to owner, notice to contractor. A notice of commencement is a document that's actually filed by the general contractor or the owner of the project, and it's a document filed in the clerk of court's office, and it sets out certain information that helps lower tiered subcontractors to file liens, to make payment bond claims, et cetera, et cetera. The notice to owner is the reverse. It's a notice that's actually given by a lower tier subcontractor or supplier. It's someone who lacks privity of contract with the GC or owner, and we'll talk about that in just 1 second. In order to file a materialman's lien, it's imperative to understand whether or not a potential lien claimant, so keep in mind this means something you have to do when you first begin working on a project in Georgia. It's imperative that you understand whether or not you have to comply with Georgia's statutory construction notice requirements. In order to determine whether or not the notice requirements apply to you, it's important to understand your relationship with the owner of the project. In legal terms, that's called privity of contract. And in Georgia, it's different than it is in other states. So the question always comes to be, how does a potential lien claimant determine whether or not they have privity of contract? If you look at the graph at the bottom of the slide, we've tried to make it very simple. If you are contracted with the project owner, then the Georgia statutory scheme does not apply to you. No notice is required. If your contracting party is the general contractor, then no notice is required. In those instances, even though you're not working with the owner, Georgia law says that you have privity of contract with the owner because the general contractor is an agent of the owner. And as an agent, the general contractor has hired you. They know that you're on the job, and it's their obligation, their responsibility to flow the money downstream to you. If you are contracting with a subcontractor or lower, then notice is required. And that then allows the owner and the general contractor, when they're making payments, to know that the payments are filtering downstream to someone who's 3rd tier or below. If you provide services to any subcontractor or 3rd tier, if you're 3rd tier or lower, then you have to comply with Georgia's construction notice scheme. And there's 2 things that are very vital for this. The first one is you have to send the notice to owner. I'm going to use the phrase NTO to refer to notice to owner and notice to contractor. You must send the NTO within the first 30 days that you begin working on the project. The second obligation is that the NTO has to include the following 6 items. It has to have your contact information, including your telephone number. We actually recommend putting a particular employee's name or project manager's name or a contract administrator person's name. That way, if and when someone higher tier, such as the general contractor or owner, wants to get a lien waiver or has a question, they have somebody who can actually answer their questions. But having an actual person's name is not required under the statute, just the contact information, which is address and phone number. You also have to have the name and the address of the entity with whom you contracted. That allows them to make sure that they can flow the money downstream. They know who to be watching to make sure that the money gets down to you. The third thing is you have to have the name of the project. This gets a little tricky. You have to have the name of the project as identified in the notice of commencement. So it's a good idea to request or get a copy of the notice of commencement before you send the NTO, keeping in mind all this has to be done within the first 30 days that you begin on the project. In addition, you have to have a description of the materials, labor, services which you'll be providing. That could be a very vague description. You don't have to itemize things. It could be something as simple as supplying electrical conduit and related materials. It does not have to be an itemization. The next piece that has to be included is the anticipated contract value of the goods or services you're providing if you know them. If you don't know them yet, then it's wise to state that in your NTO. If you do have a concept of what the value is, what the contract value is, include that, but you might want to include some sort of particular language that says, which may be amended or may be altered by future financial arrangements, future contracts, etc. And then finally, the notice to owner must be sent to the GC and to the owner to their addresses as they listed in the notice of commencement. So again, you need to have that notice of commencement in hand in order to do this. If you must send an NTO, if the Georgia statutory notice scheme applies to you and you fail to send the NTO, then your lien will not be enforceable. The clerk may accept your lien, it may be filed, but it will not be enforceable. You will not be able to collect. And so it is very important when you first begin working on a Georgia project to understand whether or not you have to send an NTO. Number two, and this may be the most difficult one or the most tricky one that we have, but the second reason why liens fail in Georgia is the failure to timely file a Georgia lien. It seems very easy up front, but as you'll see in 1 second, there are some tricky or technical issues that complicates this a little bit. Generally, in Georgia, liens must be filed within 90 days of the last day in which the materials, services, or labor were provided to the project. Keep in mind that's not invoice date. So if you invoice at the end of the month, but your last day worked was, say, the 22nd or 23rd, that 90-day period begins ticking from the 22nd or 23rd, not the invoice date. 90 days from last day worked is fairly easy to calculate. However, there's one significant exception to this that impacts a lot of people negatively. If you are required to sign a lien waiver prior to receiving payment, if you have to submit with your pay app or with your invoice, an unpaid lien waiver can reduce the amount of time you have in order to file a lien. But back up for 1 second. Georgia only has 2 valid lien waiver forms. That's an important distinction to recognize, valid forms. There's no way that I can tell you over the phone what a valid form is, but it's in the statute. Any lawyer can certainly help you with that. It's fairly easy to find online. It's an ugly form, to be honest. It's all caps and it's difficult to read. But the 2 forms, that we have an interim waiver and then we have a final waiver, and they're substantially similar forms, but they are very tricky. They are conditional for 60 days. And what that means is the lien waiver does not kick in until a condition has been met. So in other words, you'd fill out a lien waiver form that you're owed $25,000 on a project. Upon payment of that $25,000, then you waive your right to file a lien. But as I mentioned, they're tricky. So after 60 days, Georgia's lien waivers become unconditional. What that means is no matter what, it doesn't matter whether or not you have received your payment, you have waived your right to file a lien unless you take certain steps. And so it is essential to watch the deadline and enforce your rights before the end of the 60-day conditional period. It's important to note that the 60-day deadline runs from the date of the lien waiver. It has nothing to do with the last day on which you actually worked on the project. Furthermore, the 60 days runs even if you continue to work on the project, which anybody who's been in the construction industry a long time understands that slow pay doesn't mean you walk off the job. It just means you're not being paid as quickly as you're supposed to be. Well, this can catch people up in Georgia. So be careful. If there's continuing work on a project, but payments are slow, then you might accidentally forfeit some of the money you're owed. This is so important that I've set forth an example. We're going to go through it quickly, but if you have any questions about this, be glad to answer it. Let's assume for a second that you enter into a 9-month contract that begins on January 1st and is completed at the end of September. Let's say that it's a $900,000 contract, which means you I mean, of course, this wouldn't happen in real life, but let's say the pay apps are for $100,000 each of the 9 months. So pay apps 1 through 3, which is January through March, the general contractor or the owner pay fairly promptly, a little slow, 30 to 45 days after you submit your pay app. Pay apps 4 and 5, which is April and May, they become tardy payments. You ask where the payment's coming, and they say, oh, we're going to pay you next week, we're going to pay you next week. And sure enough, in about 45 or 60 days, the payments arrive. Then the last 3 pay apps, the June through September pay apps, they're not paid. Of course, the project's ending. They keep promising payments. You continue. Finally, you finish the job. What most people think, if you look at the box on the lower left-hand part of your screen, is that the last day worked is September 30th. So you can file a lien for the full amount, which would be June, July, August, and September's pay apps, and you have until December 29th to file that lien. Well, that's not true, unfortunately, in Georgia, if you signed a valid lien waiver. What really happens, if you direct your attention to the right, is that the ability to collect the June 30th pay app expired August 29th. The ability to collect the July 31st pay app expired September 29th. The August 31st pay app expired August 30th, and September 30th pay app expired November 29th. So the question then becomes, have you lost $100,000, $200,000, $300,000, or $400,000? So be very mindful of Georgia's lien waivers. So what we tell clients when they want to calculate the deadline for filing a lien, we always say that Georgia's materialman liens must be filed either 1, within 90 days of the last day worked, or 2, within 60 days of the earliest unpaid lien waiver, whichever is shorter. Incidentally, there are some other things you can do with an unpaid lien waiver rather than filing a lien, but typically a lien is the recommended and easiest and least expensive thing to do. Moving on to number 3. The third reason why liens fail in Georgia is your lien does not properly attach. And if it doesn't properly attach, then it will be invalid. You know, whether or not a lien attaches to a particular piece of real estate can be a very complex legal question. However, the 2 common mistakes that we see when people file their own liens, people come to us and they tell us this information, and then we have to end up correcting it. The first one is correct identification of the owner. If the owner is not identified correctly, then the title abstractor may not discover your lien, and that's a big deal. When you file a lien, you want to prevent the property from changing hands. You want to be ahead of any future creditor or lender to the owner of the property, so you want that lien to pop up. That way you basically get paid before those events occur. However, if the name is misspelled, something as simple as that, the title abstractor is not going to find your lien, and it probably will not be enforceable against any transfer to third parties. Other things to think about is you must include all the owners, and so frequently, particularly in a husband and wife situation, but there are plenty of others, you have to include the joint tenant. Maybe you think party A owns it when really it's party A and B, or perhaps the property has already been deeded to some children, so maybe 3 or 4 owners to the property. You must identify each and every one independently. Similarly, individuals often put their property in trust, so it's important to recognize it's not just John Smith's property, but it's the irrevocable trust of John Smith dated January 1st, 2014 that actually owns the property. We see a lot of times in commercial properties that they are different but similar names, and so ABC Company may become ABC Parcel 1 Company, ABC Parcel 2 Company, and so it's very important to make those distinctions. Failure to do that will invalidate your lien. Secondly, the second big problem that prevents attachment of the lien to the property is the correct identification of the real estate. We don't recommend using street address typically, particularly on new construction. A lot of times the street addresses are not known or difficult to find. Also, you want to make sure that your property is picked up by a title abstractor, and so we always recommend using a meets and bounds legal description. So many people rely upon the tax office information for ownership and deed information. While that may be a useful starting point, do not rely upon that. Georgia has 159 counties. Of those counties, the vast majority update their lien record once a year, and that gives a lot of opportunity for transfers to occur, and so you may not be identifying the correct owner if you rely solely upon that information. And the fourth and final reason why liens fell in Georgia is the failure to perfect the lien. So many people think that when they file a lien, it lasts forever and they're going to get paid. Well, that's unfortunately not true. In Georgia, liens automatically expire unless they are perfected. So you say, when do they expire? Generally, liens expire 395 days from the date that they are filed. If an owner or general contractor has filed a document called a notice of contest of lien, then the lien will expire 90 days from the date of the notice of the contest of lien. So how do you make your lien exist beyond that 395-day period or that 90-day period? You must perfect the lien. Generally, the statute requires that you must take steps to enforce your lien within that time period. There are several different methods, could include such things as mediation, arbitration, or pursuing something in bankruptcy court if one of the parties has filed bankruptcy. But the typical, most common means of perfecting the lien is filing a lawsuit against the entity with whom you contracted. You have to do that before the deadline, and the deadline is a little bit different than the deadline, than the expiration date of the lien. The deadline to file this suit or take this action is 365 days from the date the lien was filed, or 60 days from the date of the notice of contest, whichever is shorter. In addition, within 30 days of taking that action, filing a lawsuit, for example, then you must also file a document in the lien record that is called a notice of filing of action to enforce materialman's liens. Basically, it connects the dot between the lien that you filed, the lawsuit or other action you've taken, and lets the world know that you've perfected your lien and your lien is good for at least 21 years in Georgia at that point. And so hopefully you'll get paid by the owner at some point without even having to foreclose the lien. So real quickly, the summary of the 4 reasons why Georgia liens may not be enforceable. First one is failure to comply with Georgia's statutory construction notice requirements. Second one, timely filing of the Georgia lien. Be very mindful of the lien waivers and that 60-day deadline. If the lien does not properly attach, then it will be invalid. And then you also have to perfect the lien, otherwise it will expire and be meaningless. So that is all I had. I'm certainly willing to take questions.
Mark, that was absolutely fabulous. And if anyone has any questions, you can ask in the lower right-hand corner of the GoToWebinar panel. Leave out any names and we can answer those for you. So far, we don't have any questions, but if you're nervous to even ask a question, you can always email Mark, or of course you could email me and I could forward on your questions to Mark.
Wow, we did a great job to put everybody to sleep.
I think they're taking in all the information, and perhaps we'll have a few questions for you later today.
Absolutely.
Well, you did a fabulous job, and I wish everyone a great rest of the day.
Thank you, Ariella. Thank you all for participating.
Thank you. Bye for now.